Ginny Thomas has been a steadfast advocate and defender of her husband, Supreme Court Justice Clarence Thomas, since his contentious confirmation hearing in 1991, when he faced credible allegations of sexual harassment of Anita Hill and other women. She's also been a fierce and vocal advocate for conservative issues that often land in the lap of her husband. In fact, no spouse of a sitting justice has ever been as openly politically active as Ginny Thomas. The bombshell revelation from the Washington Post and CBS that she sent 29 text messages to Donald Trump's chief of staff, Mark Meadows, promoting QAnon conspiracy theories to justify overturning the 2020 election, has now cast yet another shadow over Thomas and the supposed impartiality he claims to espouse on the bench. Weirdly, Ginny Thomas isn't Justice Thomas's only connection to January 6th. His former law clerk, John Eastman, was responsible for providing the former president with the dubious legal justification to steal the election. All of this just makes you go, But I think former news anchor Dan Rather put it best when he tweeted, "What does Clarence Thomas know, and when did he know it?" Interestingly enough, back in March, Mrs. Thomas sat down with the Washington Free Beacon almost as if she knew something was coming and admitted that she went to the Stop the Steal rally at the Ellipse on January 6th, but claimed she left because it was too cold. She denied that her attendance created any conflict of interest, telling the Examiner, "Like so many married couples, we share many of the same ideals, principles, and aspirations for America, but we have our own separate careers and our own ideas and opinions, too." And by sheer coincidence, Justice Thomas was the lone dissent in the Supreme Court's January order rejecting Trump's bid to withhold documents from the January 6th panel, which we should note only included documents held at the National Archives. And yet, while they claim intellectual independence, the Thomases have long emphasized how little distance there truly is between them. In February, the New York Times reported that Justice Thomas once told a crowd, which had gathered to celebrate his 30 years on the court, that the 1991 confirmation hearing had the effect of melding us into one being. So, given what he has said and how they've behaved, how are we supposed to believe that a married couple melded into one being have no clue what the other is doing? Supreme Court justices are afforded a significant amount of leeway when it comes to the judicial code of conduct. In fact, they are free from them. However, they are subject to a federal law that prohibits them from hearing cases in which their spouses, and in this case, Ginny, have an interest that could be substantially affected by the outcome of the proceeding. Joining me now is Melissa Murray, NYU law professor and former clerk for then Second Circuit Court Judge Sonia Sotomayor, and Paul Butler, Georgetown law professor and former federal prosecutor. Thank you both for being here. Melissa Murray, I'm going to start with you. You clerked for Sonia Sotomayor, and I will note it was before she was a Supreme Court justice, but I just wonder what you make of this, because I can't think of any other justice. I knew that Ruth Bader Ginsburg was married, and we heard some things every so often about what her husband did with his time. I've never heard this much about any other Supreme Court justice's spouse. Have you? And what do you make of these text messages?
Well, I think Supreme Court spouses try to avoid any appearance of impropriety, in part because the court's legitimacy really does depend on the public viewing the justices as being above reproach. So, for example, Chief Justice John Roberts' wife had been very active among a group of pro-life feminists, and she left her position doing that work when he became Chief Justice because of the obvious implications that it would have for his work as Chief Justice. We have never seen anything like Ginny Thomas in our history, in the history of Supreme Court spouses. And again, the deep imbrication of her work with her husband's work, I think, is hard to overlook. Often it seems from this reporting, what she has been peddling as a consultant in Washington, D.C., is access to the corridors of power. And, you know, the real question is one of those corridors in her own home?
And I mean, it's not even just the first time. This is element 6 from my wonderful producers. Virginia Thomas has been active and an advocate for repealing the Affordable Care Act, which came before the Supreme Court, repealing Roe v. Wade, just sneaking its way towards the Supreme Court, repealing COVID mandates before the Supreme Court, targeted strategies that make it easier to vote, mandatory voter identification laws. She floated the idea of using former Navy SEALs to monitor the polls, overturning the 2020 election, repealing affirmative action, anti-transgender rights. That's just what we know of. And so it seems to me, to stay with you for a moment, Melissa, there is no instance throughout this man's career when she hasn't been advocating on something that he's ruling on. I've never seen anything like that. She definitely feels sui generis to me. Your thoughts?
It is sui generis. I mean, and the optics are poor, but to me, what really smacks of impropriety and probably needs to be investigated further is the notion that many of the individuals who appear before the court as litigants are also Ginni Thomas's clients. So it's not simply that she has particular views and that she's a vigorous advocate for them in Washington. It's that she's actively advising those who regularly appear before her husband as litigants.
And including, it appears to be Mark Meadows. Let's bring you in here, Paul Butler. Here's the NBC reporting. This is new reporting on top of what we saw in the Washington Post and CBS. Thomas wrote to the aide, to an aide, a White House aide, that Freedom Caucus members were tougher than the Republican Study Committee members were in the fight, and had then President Donald Trump's back, according to the source familiar with email clients, until she saw RSC members, and I guess she means Republican Study Committee members, out in the streets and in the fight. She would not help the Republicans, the largest caucus of conservatives on Capitol Hill. So she's essentially ordering Republicans to get out there and fight. There's a text message where she calls the election a heist, saying, help this great president stand firm, Mark, with all these capitals, telling him, you're the leader with him who's standing for America's constitutional governance on the precipice. The majority knows Biden and the left are attempting a heist, blah, 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 blah. She orders Mark Meadows, do not concede. It's time for the army who's gathering to have his back. It keeps going. She supports Sidney Powell and says, let her be the face of this. Oh, release the Kraken. She goes on, and she has a threat involved. If you don't do it, she says, I and 73 million people like me are going to be done with politics. This feels like she is advising the chief of staff to the president, Paul, in the midst of an ongoing insurrection against our country. And then her husband rules, and I don't care if it's not the same emails. Her husband then is the only justice who says, nah, Donald Trump's presidential record should be sealed because he's got immunity. Your thoughts?
Joy, Ginni Thomas actively tried to install the losing candidate as president. If she had her way, we would all be living in a Donald Trump dictatorship right now. She had unique access to Mark Meadows, the chief of staff, arguably the most powerful person in the country after Trump himself. And Thomas was the only holdout in an 8-1 decision that allowed Congress to obtain records from Trump's White House related to January 6th. Guess whose records those include? Mark Meadows. Justice Thomas would not have allowed the public to see those records, and now we kind of know why. And Thomas's lone dissent in that case was legally incoherent, which is why even ultra-conservative justices like Alito and Gorsuch couldn't go there.